An almost reverent silence settled over the grand conference hall at the University of Chicago Law School. The polished wooden benches and high-arched ceilings lent a certain gravity to the moment. Seated at the center of the stage was Judge Richard Posner, one of America's most revered legal minds. Behind the speaker's podium, his keen eyes, usually brimming with certainty, now betrayed a flicker of disbelief. He was known for his unyielding intellect and, at times, his famously sharp tongue. Just moments earlier, Judge Posner had dismissed Congresswoman Jasmine Crockett as little more than a politician pretending to understand the law. A sharp collective gasp had risen from the audience of law students, professors, and journalists. Many leaned forward in their seats, sensing the room was about to witness something extraordinary. At the microphone, Crockett remained calm, almost serene. In her hands was a thick folder, neatly organized with color-coded tabs. Her measured tone carried easily. "Judge Posner," she began, her voice steady, "you've questioned my legal credentials. You've suggested I'm just another politician who has left the real practice of law behind." She glanced briefly at the students in the front row. "Well, I'd like to share something with you and with this distinguished audience that might change the perception." The atmosphere became electric. Law students leaned forward in unison, their notebooks ready. Distinguished professors adjusted their glasses, and journalists gripped their pens. This wasn't going to be another polite exchange of academic arguments. It was about to become a moment that would challenge how people thought about expertise, professionalism, and respect in the legal world. To appreciate the magnitude of this clash, it's important to understand the stature of these two figures. At 84 years old, Judge Richard Posner had spent more than 3 decades shaping American jurisprudence on the Seventh Circuit Court of Appeals. He had authored over 3,000 judicial opinions and written more than 40 books on law, economics, and philosophy. His reputation for intellectual rigor was legendary. His critics called him arrogant. His admirers hailed him as one of the most brilliant legal thinkers of his time. Even in retirement, his writings continue to influence law schools and courtrooms across the nation. Jasmine Crockett, by contrast, was relatively new to the national stage. At 43, she had first made her mark as a civil rights attorney in Texas, building a reputation as a tireless advocate for marginalized communities. She earned her law degree from the University of Houston Law Center and spent over a decade litigating in trial and appellate courts before entering politics. Yet for many in the traditional legal establishment, including Posner, her transition to Congress marked, in their eyes, an abandonment of serious legal work. What Posner and most of the audience didn't know was that Crockett had never stopped practicing law. Even while serving in Congress, she continued to take on pro bono cases, particularly those involving civil rights and constitutional challenges. Much of her work had flown under the public radar, but it had been consistently impactful. As Crockett's calm but confident presence filled the room, it was clear this was not going to be a mere exchange of words. The tension in the air was almost palpable, as if everyone knew they were about to witness a defining moment, not just for the two individuals on stage, but for how the intersection of law and politics is understood in America. The confrontation that would soon become legendary began at a symposium titled Law and Politics in Modern America. The event was intended to foster thoughtful dialogue about how legal expertise shapes political decision-making. Federal judges, renowned professors, and political leaders filled the hall. Cameras from legal news outlets and student journalists lined the aisles. Judge Posner had been invited as the keynote speaker. His speech that evening was, as expected, both brilliant and provocative. With characteristic candor, he argued that America was witnessing a decline in serious legal reasoning among politicians. Too many elected officials, he insisted, were using their law degrees merely as a badge of credibility while abandoning the intellectual rigor required to interpret and apply the law. "When you trade the courtroom for the campaign trail," Posner declared, "you too often trade arguments based on statutes and precedents for slogans and sound bites. We must be honest about this trend." Many in the audience nodded. His critique of political lawyers was not new, but it carried extra weight coming from a figure of his stature. When the question and answer session opened, Crockett approached the microphone. She had been invited as one of the few political representatives on the panel, but her tone was respectful, professional. "Judge Posner," she began, "in your remarks, you suggested that political involvement diminishes one's capacity for serious legal reasoning. I'd like to ask about a recent Supreme Court decision on constitutional interpretation. Specifically, how you view its implications for separation of powers in light of current legislative debates. For a moment, Posner looked intrigued, but then he responded with a dismissive half-smile. Congresswoman, I fear that politicians rarely grasp the nuances of constitutional doctrine. Their focus is on immediate political outcomes, not on the consistent application of legal principles. It's precisely the problem I've been describing. A few professors shifted uncomfortably in their seats. The tone of the exchange had turned sharper than expected. Crockett maintained her composure. Respectfully, Judge, understanding those nuances is essential to crafting legislation that will withstand judicial scrutiny. If lawmakers don't engage seriously with constitutional doctrine, we risk passing laws that cannot stand in court. Before she could continue, Posner interjected. I have no doubt of your sincerity, Congresswoman, but sincerity is not the same as expertise. I suspect you haven't been in a courtroom or drafted a serious brief in quite some time. A murmur spread through the audience. Some students raised their eyebrows. Others glanced at one another in disbelief at the bluntness of the remark. Undeterred, Crockett tried again, shifting the discussion to federal appellate procedures and their potential impact on pending legislation. Once again, Posner responded with an air of condescension. Your question illustrates exactly what I mean. Politicians often lack a practical understanding of how appellate courts function. The room went still. Then came the comment that electrified the hall. Posner leaned slightly toward the microphone and said in a tone both firm and faintly patronizing, Congresswoman, with all due respect, you're what I would call a fake lawyer. You have a law degree, yes, but you've become a politician. You've abandoned the discipline of serious legal work for the theater of politics. I doubt you've been inside a real courtroom or drafted a meaningful legal brief in years. The words hung in the air like a thunderclap. A collective gasp rose from the audience. Several law professors exchanged uneasy glances. A few students instinctively began typing furiously on their laptops, already composing tweets that would go viral before the evening ended. But the person at the center of it all, Jasmine Crockett, did not flinch. She did not argue or raise her voice. Instead, she offered a small, calm smile, turned back to her seat, and picked up the large folder she had brought with her. When she returned to the microphone, the mood of the room shifted. Her voice was steady, but carried a subtle edge. Judge Posner, I appreciate your honesty, she began. I think this is the perfect moment to have a real conversation about what legal expertise truly means in modern America. The room fell silent once again, sensing that the confrontation was about to take a decisive turn. The atmosphere in the hall was so still you could hear the soft rustle of papers as Crockett placed her folder on the podium. Her calm demeanor contrasted sharply with the tension rippling through the crowd. Students leaned forward. Professors exchanged glances. And even the journalists, usually jaded by political drama, sat poised with pens and cameras, sensing they were about to witness something extraordinary. Crockett opened the folder with deliberate care. The thick stack of documents was tabbed, color-coded, and professionally bound. This was not the prop of a politician seeking a sound bite. It was clearly the working file of a serious attorney. Judge Posner, she began, her voice firm yet controlled, you've suggested that I'm just another politician who has left behind the discipline of practicing law. You've called me a fake lawyer. Rather than argue about it, I'd like to respond with evidence. She held up the first document so that even the students in the front row could see the thick brief. Just 3 months ago, I argued before the Fifth Circuit Court of Appeals in the case of Henderson versus Texas Department of Education. The case involved questions about equal protection under the 14th Amendment and disparities in education funding between districts serving wealthy versus underprivileged communities. A few heads turned in the audience. They recognized the case. It had made modest headlines in legal circles for raising new constitutional arguments about education equity. Crockett continued, flipping open the brief to a marked page. This document cites 47 federal cases, includes original constitutional analysis, and presents novel arguments about the intersection of state education policy and equal protection guarantees. The three-judge appellate panel ruled in our favor unanimously. Posner, who had been leaning back in his chair, shifted slightly forward, his eyes narrowing as if reassessing the woman standing at the podium. "But that's just one case," Crockett said, setting the brief aside and picking up another document. "6 months ago, I represented a coalition of voting rights activists in Martinez v. Dallas County, a federal district court case challenging changes to voting procedures that disproportionately affected minority communities. Here," she held up the document, "is the motion for a preliminary injunction that I drafted. It required extensive analysis of Supreme Court precedent on voting rights, detailed statistical evidence on disparate impact, and arguments grounded in both the Equal Protection Clause and the Voting Rights Act." She glanced at Posner as she continued. "The federal judge granted our motion, and in his ruling, specifically praised the quality and depth of our legal analysis." The room was quiet enough to hear the soft scratching of pens as students frantically jotted down notes. Crockett moved to a third document, even thicker than the others. "Last year, I took on a pro bono immigration case, Ramirez v. Department of Homeland Security. This was no simple matter. It required navigating complex intersections of federal administrative law, constitutional due process, and international treaty obligations." She held the brief high so that everyone could see its thickness. "This brief is 89 pages long and includes arguments that had never before been presented in federal court about the intersection of asylum law and constitutional protections for families." The presiding judge described it as exemplary legal scholarship, and we won the case. A ripple of murmurs passed through the audience. Law students looked astonished. Professors exchanged quiet nods of respect. Even Posner's once confident posture softened as his sharp gaze fixed on the documents in Crockett's hands. "As you can see," Crockett said, her voice unwavering, "my work is not limited to legislative speeches or political sound bites. These cases demonstrate that I remain an active practitioner of law, engaged with some of the most challenging constitutional and statutory questions facing our courts today." She closed the folder gently, her eyes meeting Posner's. "So, Judge, when you question whether I've been in a courtroom recently or written serious legal briefs, I'm happy to let the record speak for itself." The silence that followed was unlike the earlier tense hush. It carried the weight of recognition. For the first time that evening, the balance of authority in the room had shifted. The stillness in the hall deepened as Crockett rested her hand on the folder, her composure unshaken. Her eyes scanned the audience before settling once more on Judge Posner. "But Judge," she said evenly, "you didn't just question my recent legal work. You implied that politicians like me don't understand how federal courts actually operate. I'd like to address that misconception as well." She opened the folder again and pulled out a slim but carefully organized stack of papers. "Here is a record of the cases I've litigated over the past 2 years. While serving in Congress, I have filed briefs in federal courts in Texas, Louisiana, and Illinois. I have argued motions before federal magistrates, district judges, and appellate panels. I've won preliminary injunctions, survived motions to dismiss, and successfully appealed adverse rulings." The students in the front row exchanged glances, clearly impressed. Several law professors nodded, recognizing the logistical and intellectual challenge of balancing legislative duties with active litigation. Crockett's tone sharpened slightly as she continued. "And perhaps most important of all, I have done this work pro bono. I don't take fees for these cases because my congressional salary allows me to serve clients who could not otherwise afford experienced federal litigation counsel." A soft murmur ran through the audience. The idea that a sitting member of Congress was voluntarily handling complex litigation for free struck many as remarkable. Judge Posner removed his glasses and polished them thoughtfully, an old habit those familiar with him knew signaled he was genuinely reconsidering his position. Crockett then reached for one final document, this one bound with a dark blue cover. "Judge Posner, there's one more case I think you'll find particularly significant. 3 weeks ago, I filed this petition for certiorari with the United States Supreme Court in Thompson v. Federal Bureau of Prisons." A rustle of interest moved through the audience. Everyone present understood the significance of such a filing. "This petition," Crockett continued, "raises a novel constitutional question: How the Eighth Amendment's prohibition on cruel and unusual punishment should apply to conditions in federal prisons. To prepare it, I conducted extensive research into Supreme Court precedent, analyzed existing circuit splits, and developed an original constitutional theory to guide future case law. She held up the petition, its formal binding gleaming under the stage lights. The Supreme Court Clerk's office accepted this petition for filing without requesting a single revision or correction. That alone speaks to the quality and precision of the work. The room seemed to hold its collective breath. Even the journalists had stopped typing as the weight of the moment settled in. "So, Judge Posner," Crockett said, her voice calm but resolute, "I want to return to your earlier words. You called me a fake lawyer. You suggested I had abandoned serious legal thinking for political theater. Yet what I have presented here tonight is evidence of active federal litigation, complex constitutional argumentation, and engagement at the highest levels of our judiciary." She set the petition down on the podium and folded her hands. "This is not political theater. This is the practice of law at its most demanding and sophisticated level." For the first time since the exchange had begun, Judge Posner's expression shifted from skeptical to reflective. His posture softened. His gaze remained fixed on the stack of documents that now served as undeniable proof of Crockett's continued commitment to the discipline of law. The audience remained utterly silent, as if the entire hall understood that the next word spoken would mark a turning point, not just in the conversation, but in how this confrontation would be remembered. The silence stretched for what felt like a full minute. All eyes were on Judge Posner, who sat motionless behind the podium, his fingertips pressed together, staring at the documents laid out before him. Finally, he reached for his microphone. His voice, when he spoke, was markedly softer and carried none of the earlier dismissiveness. "Congresswoman Crockett," he began, "I owe you an apology." The words hung in the air like a thunderclap. The students in the audience shifted forward in their seats. Even the veteran professors leaned in. They all knew how rare it was for the famously sharp and stubborn Judge Posner to concede a point, let alone apologize publicly. "When I called you a fake lawyer," Posner continued, his gaze steady on Crockett, "I was speaking from assumptions rather than evidence. That is precisely the sort of intellectual laziness I have spent my career criticizing in others. I was wrong, and I was unfair." A quiet ripple moved through the audience, half gasp, half sigh of relief. Some of the students exchanged wide-eyed glances as if they were witnessing legal history being made. Crockett nodded respectfully. "Thank you, Judge Posner. I accept your apology, but I believe this moment reveals something deeper about how we, as a profession, sometimes judge one another." She closed the folder, but left her hand resting on it. Too often we assume that a lawyer's competence can be measured by their current title or the institution they work for. We overlook those who practice law in unconventional roles or outside the traditional paths of firms, courts, or academia, and as a result, we miss out on the expertise they bring. Turning slightly to address the audience, Crockett's voice took on a thoughtful but firm tone. How many brilliant legal minds are underestimated because they serve in public office, or run small community practices, or devote themselves to pro bono work? How many are dismissed as not serious because they aren't in a courtroom every day or publishing law review articles? Judge Posner nodded slowly, the corner of his mouth lifting in a wry, self-reflective smile. "You're right," he said. "I fell into the very kind of categorical thinking I've often warned others against. I saw a politician and stopped seeing the lawyer behind the title." The tension in the room eased, replaced by a palpable sense of mutual respect. Students who had been furiously scribbling notes now looked up, watching as an exchange that had begun as a clash of egos transformed into an authentic dialogue. Crockett took a step closer to the podium. "And I'll add this," she said. "The work I've shown you tonight, the briefs, the motions, the petition for certiorari, is just a fraction of what lawyers in non-traditional roles are accomplishing. There are prosecutors turned senators drafting criminal justice reform bills grounded in their courtroom experience. There are former civil rights attorneys shaping state policies with deep constitutional insight. And there are legislators like me who continue to litigate when the stakes for our communities demand it." Her words landed with quiet authority, the truth of them reinforced by the documents she had presented. The audience sat riveted, realizing they were witnessing not just a debate, but a moment that would likely be studied in law schools for years to come. Crockett reached for another document from her folder. This one was slimmer than the rest, but bore the official seal of Congress. "Judge Posner," she said, holding it up, "this is the Federal Court Efficiency Act, a piece of legislation I drafted. I'd like you to take a look." Posner's brows furrowed. He had spent years writing and speaking about inefficiencies in the federal court system, so the title alone caught his attention. A student in the front row carried the document to the podium. Posner adjusted his glasses and began to scan the text. Crockett continued speaking to the audience as Posner read. This bill was designed in direct response to the procedural delays and burdens that slow our judicial system. It includes reforms to discovery procedures, introduces streamlined alternative dispute resolution options, and reallocates judicial resources based on case complexity. Each provision is supported by empirical research, constitutional analysis, and, I should note, builds on ideas you yourself advanced in your book, How Judges Think. At that, Posner glanced up at her, his expression shifting from polite attention to genuine intrigue. "You've read that book closely," he said, half to himself. "Yes," Crockett replied with a small smile. "Because it offered practical insights about making courts more responsive and effective. Insights I thought should move from theory to policy." She went on, "Too often the gap between legal scholarship and legislative action remains wide. We talk about what the law should do in journals, and then we legislate as if that scholarship doesn't exist. My goal with this bill was to close that gap." Posner looked back at the pages, his fingers pausing on a section highlighted with annotations. "This proposal for case tracking by complexity," he murmured. "This is something I advocated for years, but never saw implemented. You're applying it in a legislative framework." "Exactly," Crockett said. "And that's why I reject the idea that being in public office means you stop thinking like a lawyer. The law isn't just something we argue in court. It's something we build into the very structures that govern our courts." The audience watched the exchange with rapt attention. Students who had entered the hall expecting a combative debate were now seeing an unexpected intellectual meeting of minds. A few professors nodded to each other, recognizing the significance of what was unfolding. Posner looked up again, this time with an unmistakable note of respect in his voice. "This," he said, holding up the bill, "is serious legal work. It doesn't just diagnose problems. It proposes evidence-based solutions. If more legislation looked like this, the courts might actually function the way we've always hoped they could." A ripple of quiet approval moved through the room. Crockett inclined her head slightly. "Thank you, Judge Posner. That's the entire point. I've tried to use the discipline of legal reasoning to craft better policy, not abandon it." What had begun as a confrontation was now evolving into something far more meaningful, a public recognition that rigorous legal thinking can thrive beyond traditional boundaries, shaping not only court cases, but the laws that frame them. Crockett then reached into her blazer pocket, pulling out her phone. She glanced at the screen, her brow lifting just slightly as if surprised by something she saw. "Judge Posner," she said, her voice steady but carrying an undercurrent of excitement, "while we've been speaking, I received a news notification. I think you'll find it timely." She turned the phone toward him so he could see the headline glowing on the screen. "The Supreme Court has just granted certiorari in Thompson v. Federal Bureau of Prisons, the petition I drafted and filed 3 weeks ago." For a heartbeat, the room was utterly still. Then, as the significance sank in, a collective gasp rippled through the audience. Law students shifted forward in their seats. Professors exchanged glances of astonishment, and several journalists began typing furiously. Posner's eyes widened. "Granted certiorari," he repeated, his voice softer, almost reverent. "That's extraordinary." Crockett nodded. "It is. Fewer than 1% of petitions even reach that stage. This one raises critical questions about Eighth Amendment protections and the treatment of prisoners, issues we've both written about, albeit from different angles." The respect in her tone was genuine. Despite the tension of the earlier confrontation, this was a moment of shared professional gravity. Posner slowly set aside the legislative document he'd been holding and stood, turning to face Crockett directly. "Congresswoman Crockett," he said, his voice carrying the weight of his decades on the bench. "Not only do I owe you an apology for questioning your credentials, but I owe you congratulations. To have a case you personally litigated taken up by the Supreme Court, that's an achievement that eludes many of the finest lawyers of our time." He stepped forward and extended his hand. Crockett accepted the handshake firmly but graciously. "Thank you, Judge Posner. I didn't set out to prove anything to anyone. I set out to do the work. But I appreciate your words." The audience erupted in applause, spontaneous, sustained, and tinged with genuine admiration. Law students stood, professors smiled, and even the journalists paused their typing to capture the historic handshake. When the applause subsided, Crockett turned back to the audience. "I want to be clear about something," she said. "This moment isn't about proving that one lawyer is better than another, or that I've somehow won this exchange. It's about reminding all of us that legal expertise can come from many places. It doesn't always wear a robe or sit behind a bench. It doesn't always bill by the hour at a law firm. It can be found in public defenders, in policymakers, in pro bono advocates. We all serve the same system of justice." Posner gave a small nod. "And today," he said, "you reminded me that evidence, not assumptions, should guide our judgment, something I've spent my life preaching, and apparently needed to relearn." The room broke into applause again, this time warmer and more personal. A confrontation that had begun with sharp words ended in mutual respect, an unforgettable lesson in humility, integrity, and the power of evidence to reshape minds. If you enjoyed this deep dive into the extraordinary courtroom-style exchange between Judge Posner and Congresswoman Jasmine Crockett, make sure to hit that like button and subscribe to Clashpoint for more powerful stories of political and legal showdowns that shape our world. Turn on the notification bell so you never miss our latest breakdowns of the moments that change history. Drop a comment below and tell us what part of this confrontation impressed you the most. We love reading your thoughts and featuring your reactions in future videos.